Okay, welcome back, folks. We're getting ready to start with part two of our Women in Social Security webinar. For those of you that were with us at part one last week, welcome back. For those of you that were not, then just plain welcome. And we're looking forward to another information-packed session, although this one, I have to tell you, is going to be a lot more detail than last week. So that's why I sent to you yesterday the copy of the presentation materials that we're using. Some of the charts are fairly dense, and so I wanted to be sure that you had a copy of them to use. So I sent you also a copy of last week's as well. And also the last week's session and this week's session are being recorded and are going to be posted on our website, amacfoundation.org, on the videos page. If you go there, click on the Social Security button, you'll see the videos. Right now, you'll see the video from last week, and the video from this week will be up shortly. So with that, I'd like to get into part two of our seminar. And as is our unfortunate standard practice, I have to read you the disclaimer. And let me just quickly read through it. The views presented today are provided by the AMAC Foundation's Social Security Advisors, accredited by the National Social Security Association, LLC. They do not necessarily represent the views of the Social Security Administration. The information presented today does not constitute financial, legal, or tax advice and should be used for informational purposes only. Since individual circumstances vary, you should consult your legal, tax, or financial advisors before making any financial decisions. And at the bottom of the screen, you see the final note. AMAC Foundation is not affiliated with or endorsed by the Social Security Administration or any government agency. Okay, now that's out of the way. Quick recap of what we talked about last week. We talked about a bunch of statistical information and why Social Security is important, particularly to women, and the things that women need to be aware of. We talked about establishing a MySSA account and the fact that pretty much these days there's not much you can do with Social Security without having a MySSA account. It's becoming mandatory. So we explained that and how to go about setting one up. We talked about how you qualify for benefits and how you actually go through the process of applying for benefits. We talked about the fascinating details of how benefits are calculated, which to me is just a fascinating mathematical exercise. And we talked about the thing called the earnings test for people that elect to draw their benefits prior to their full retirement age but continue in the workforce. People that take that route need to understand the earnings test and how it impacts their monthly benefits. So we covered that in fairly detail, and we closed out with a discussion on cost of living adjustments, COLA as it's referred to, how they're calculated, and a little bit of the history on the whole COLA process. So that was last week, and again, that video is up on the website if you want to go back and refresh, or if you weren't with us last week. Just go to the website and check it out. So moving into part two, today we're going to talk about a lot of detail in terms of benefits for women and focusing on perhaps women that are single and never married. Then we're going to talk about spousal benefits. This thing called the restricted application, which is something that you hear about. And a lot of people get confused by it. So we'll talk about some of the restrictions on the restricted application. But it's another very interesting process. It's on the way of becoming defunct anyway. But for now, it's still active and it still applies to a segment of the population. So we'll cover that. We'll talk about deemed filing and what that means. That sounds like such a mystical term. But we'll explain what that means and how it impacts the benefits particularly for spouses. So we're also going to cover widow benefits and the effects of remarrying. A widow or a widower, frankly, that remarries. There are some rules and regulations you need to understand. We're going to talk about the whole issue of divorced spouse benefits, which it can get kind of complicated. So we're going to cover all the details on that. And we'll close with a brief discussion on common law and civil unions and how they affect Social Security benefits. So with that, I'm going to move into part two, and I'm going to turn it over to the experts here on our staff, Sharon and Eileen, and they're going to go through the details in some pretty good depth. So I think there's going to be a lot of information you're going to be getting out of this session. And again, you have copies of the slides that we're using, and the video of today's presentation will be up on the website probably later this week. So with that, I'm going to verbally exit the process and turn it over to Eileen and Sharon.
Good morning, everyone. And let's start off with single women and never married. Just a little statistics, 23.4 million women collect Social Security benefits on their own record. That means it depends on their own information, number of years worked, the Social Security earnings, the age at which they collect, and generally the longer you wait to file after becoming eligible, the higher your monthly benefit will be. Because last week we discussed about if you take, when you're first eligible for Social Security at 62, it's a permanent reduction that you're going to take. If you wait till 70, you're going to get those delayed retirement credits. And when you see the chart in the next slide, that will explain the difference. That basically, if you take your benefit at 62 and at 70, your benefit will grow 76%. Next chart, next slide, please. And so this gives you the year of birth, your normal retirement age, and then the credit for each year of delayed retirement credit after your retirement age. And this will show, if you do the math, and Sharon has done the math, we all know Sharon loves math, that it is 76%, the difference between your benefit at 62 and your benefit at 70.
Regardless of your full retirement age.
Yep. So that's important, because when you're a single woman, never married, your benefit is going to be solely on your earnings. And once you take that benefit early, other than very rare circumstances, that it's a permanent reduction. So next slide. Now we get into married women. So just to let you know that 2.3 million women or spouses represent out of 68.8 million Social Security benefits that people are collecting benefits. It represents 3.6% of Social Security. So it's important to understand the social, your spousal benefits. And it's also important to coordinate the benefits between spouses. It's critical, communication. And just to know that a lot of things happened because of the Bipartisan Budget Act of 2015, changed a lot of things for retirement planning. So as you can see, the claim, file, and suspend changes ended anyone not 66 on or before April 30th, 2016. So the last person, if my math is correct, and I have math people around me, was April 30th, 2020. Am I right, Sharon?
Absolutely. It's no one should be under it any longer, not if they want anyone to get benefits on their record.
Correct. So
Yeah, and I would interject that when that change came about as part of the Bipartisan Budget Act of 2015, it caused quite a flurry of excitement and people contacting us for guidance.
Oh,
it was just so confusing.
yes.
But we're kind of thankful here from an advisory point of view that it is in fact going away.
Yes, but we still have the restricted application.
Yeah, and there was a lot of confusion early on between file and suspend and restricted application. So
It's still out there.
yeah. So we'll be talking about the restricted application shortly, and you'll get a pretty good feel for what that means.
Okay. Next slide. So, so what is what are your spousal benefits and the term spousal boost, and how do you qualify for them? And when you're eligible for spousal benefits. So this gives you a short little chart, and then say, you know, if you file a spousal benefits at 62, and if you're your spouse is full retirement age, you're going to end up taking a cut, a permanent reduction. So, Sharon, do you want to walk them through, or should we just go on to the next slide? What do you think?
Well, this chart that you're looking at right now, it's actually applies to a non-working spouse. That's a spouse that stayed home, took care of the house, you know, raised their children. And you're not entitled to a benefit on your own record.
Mhm.
And
This-
it lets
this
you
be-
see how, and that, well, the only time you're going to get that full 50% of the other spouse that's entitled to a benefit is at your full retirement age. And your spousal benefits are actually 43% higher at full retirement age than at age 62. Doesn't look like it, but when you do the math, once again, it's actually 43% higher.
And we should note that even though it's supposed to be non-working spouse, it could be a spouse that just doesn't have enough credits to collect a Social Security benefit on their own. So they fall into that.
Any spouse that is a legal citizen or resident of the United States can receive a spousal benefit on their spouse, regardless if they're eligible on their own record or not, unless they're subject to GPO, and that's next week.
That's next week. We'll talk about that.
Yeah,
And-
just to extend that comment, they would not get both, even if they are eligible for a benefit and are eligible for a spousal benefit. They do not get both.
Mm.
You get the higher of the two, and
Yeah.
that's something that causes people a lot of confusion.
A lot of confusion.
Yeah, let me just interject one other thing. We're throwing a lot of numbers at you here, and we know it's difficult to comprehend this stuff on the fly. So if you have any questions afterwards, and we'll mention this again at the end, if you have any questions about how these numbers apply to your situation, just please feel free to give us a call at our advisory service, and the number is 888-750-2622, or you can email us at ssadvisor@amacfoundation.org. Just wanted to throw that in to keep in mind, because this stuff gets very, very complex as you try to massage the numbers. So,
Yes.
okay.
Next slide.
And this is one of the online calculators available on the Social Security Administration's website. This one is for determining the effect on your spousal benefits should you want to take it early. It's very simple to use. You enter your date of birth and the month you want to begin your benefits. Now, this calculator is geared towards spouses without their own retirement benefit. But even if you have your own retirement benefit, it's going to give you a fairly close estimate on what your spousal benefit would be.
And just an FYI for a bunch of us who look up these kind of statistics, the proportion of women age 62 receiving benefits on their husband's account, spousal account on their husband's only, declined from 57% in 1960 to 19% in 2019. Now, those who are dual eligible, that means they have a benefit and they're eligible for a spousal boost, increased from 5% in 1960 to 24% in 2019, and that comes from the SSA. So it's just interesting how women have worked and now they have both their benefit and eligible for a spousal boost. So, next slide.
Okay. Now, this chart is when you have your own retirement benefit and you're also eligible for a spousal benefit. Here's where you see the true effect of, say you're entitled on your own work record. Well, you decide to start your benefits at 62. Well, your spouse hasn't applied yet, and you cannot receive your spousal benefit until the other spouse does apply. This is another thing a lot of people aren't aware of. When you start your own retirement benefit, say at 62, even if your spousal benefit doesn't take effect until you reach your full retirement age, that reduction from taking your own benefit early is going to affect your spousal benefit. It will never equal 50% of your spouse's higher benefit, because your new base is going to be your reduced amount at age 62, and then the spousal benefit, which is the difference between 50% of the higher earners benefit and 100% of the lower earners benefit. Now, these are always based on your full retirement age, regardless when you take your own retirement benefit, regardless of when your spouse takes his home retirement. They will always start with the full retirement age benefits. So for example, here, someone with a full retirement age of 66, they decided to take their own retirement benefits at 62. Then when they reached 66 and their spouse finally filed, it shows you how much of how they get the full 100% of their own. Okay, wrong. To get the full 100%, you got to wait till your full retirement age on both benefits. You took your own benefit at 62, and say your spouse doesn't file to your full retirement age, you're still going to get the full spousal benefit, but your base is going to be your reduced benefit, and that's where you'll see the reduction and why you're not receiving that 50%.
Right.
That's Russ's chart.
Restricted application, Sharon.
Okay. It's still out there and it's still available to people, and a lot of people are still using it because you can actually use it if you were born on or before January 1st, 1954. And if you're one of those, say you're 68, you're waiting for your spouse to turn 62, they got a smaller benefit, even though you're already 68. You can, if they file, once the lower earning spouse files first, you then have the option to file that restricted application, and you will receive 50% of the lower earning spouse full retirement age benefit, even though they're taking a reduced benefit by filing at 62. This then allows the higher earners benefit to grow up to age 70 if they choose, and continue earning those DRCs, because it's not going to affect either one of your benefits.
Yeah.
So it is still available if you are in the situation where you have an older spouse and a younger spouse, but that older spouse has not yet reached 70.
Yeah. And then when the spouse, let's say, stays to 70, files for his own or her own benefit, because it can be used for both, the lower earning spouse then files for a spousal benefit.
We'll get to that. It depends on where they fall. In this situation, I'd say they'd fall under the new rules if they're only just turning 62.
Yes, we should say this. It goes under deemed filing. There's old rules and new rules.
And that's where deemed filing gets very confusing to people.
Yes. Next slide.
Okay. And another thing you need to be aware of, where a lot of people do get confused, they delay their benefit to 70, thinking that their spouse is going to get 50% of their age 70 benefit. That isn't how a spousal benefit works. A spousal benefit, once again, is only based on 50% of the higher earning spouse's full retirement age, or primary insurance amount, which is usually equal to the full retirement age. But sometimes when you work beyond your full retirement age, you increase your primary insurance amount. That's what the spousal benefit is based on, 50% of that figure. Now, you didn't delay for nothing, because those DRCs do increase the survivor benefit. Should your spouse be, that's the surviving spouse, she will receive 100% of the DRCs you earn by delaying your benefit.
And I should say that divorced spouses are the only ones that can file an application on each other. I mean,
Correct. I even help people do this. If they were divorced more than 2 years and they both reached 66, say at the same time, you can actually file a restricted application on each other. You each collected a full spousal benefit on each other, and you both increased your benefits to age 70. But only you had to be divorced to be able to do that.
Yeah.
But the last age group eligible for this strategy will turn 70 in 2023.
2 more years.
But they can use it right up to the end.
Yeah. Deem filing, the old rules.
Okay, when we say old rules, we are speaking about someone born January 1st, 1954 or before. They had, if you're in that age group, you had or may still have, depending on your situation, the lower earning spouse might be older than the higher earning spouse, so they're still waiting on their spousal benefit. Well, under the old rules, you had the option to file for your own benefit ahead of the higher earning spouse.
Yeah.
When you filed for retirement and your spouse or ex-spouse has already filed, at that point, Social Security will deem that you have filed for both your own benefit and any spousal benefit available for you. But you had the option to avoid the rule. You simply filed ahead of the higher earning spouse, took your own benefit, then the higher earning spouse could file at any time, but you weren't subject to being deemed as filing for your own spousal benefit. You could actually wait until your full retirement age, then claim your spousal benefit and receive the full spousal boost, even though the reduction from taking your own benefit early would still affect it. And this is showing you an example of how it works under the old rules, where this person decided to take their benefits at 62. Their PIA was 1,000. They took the reduced benefit. The higher earning spouse's PIA was 2,500. Well, it shows you how spousal benefits determined. They divided his higher benefit by 2, 50%. They subtracted the lower earning spouse full PIA, which made her eligible for a spousal boost of $250. But since she took her own benefit at 62, that was her base. So her new benefit would only equal $1,000 versus the $1,250. But it brought her right back to what she would have received on her own benefit. And here's another difference on the old rules with spousal benefits pertaining to deemed filing. When the lower earning spouse filed first to avoid deemed filing, and then the higher earning spouse filed, they didn't automatically get that spousal benefit at their full retirement age. You have to actually file for it, or you will not receive it. Spousal benefits do not grow beyond your full retirement age, so there would be no sense to delay taking it. And if you decide to claim it before you reach your full retirement age, of course, once again, it will be reduced, and it's a permanent reduction. And if you filed for your own benefit before full retirement age, that reduction, once again, will affect that benefit amount. Okay, now here's something a lot of people aren't aware of. When a spouse becomes eligible, even under the old rules for a spousal benefit, when that other spouse files, Social Security is supposed to notify the other spouse that they are eligible for a spousal benefit. They do this through sending you a letter. Well, this doesn't always happen, and sometimes spouses simply aren't aware they're eligible for a spousal benefit, or even aware that they have to file to claim it. And if you question whether or not you're receiving your spousal benefit, and you contact Social Security and ask them, am I eligible for a spousal benefit? Am I receiving it? If they inform you that you're not that you're eligible for a spousal benefit, but that you're not receiving it, you could receive up to 6 months of retroactive benefits. But in some cases, that retroactivity can actually extend all the way back to the initial date of your spouse's original application or your full retirement age, whichever you choose. But of course, the burden of proof rests with you. Now, Social Security does keep on file a copy of the letter they would have sent you notifying your spouse that she was eligible for a spousal benefit and she needed to apply. Now, if they have a copy of that letter on file, it doesn't matter if you received the letter or not. You're only going to receive 6 months of retroactive benefits. If they don't have a copy of you ever being notified, that's when you can request those spousal benefits all the way back to the date of your spouse's original application.
And we've had a couple of instances where this has happened.
I've helped more than one.
Yeah.
And Social Security was really good of going, uh-oh,
Yes.
and making it right.
Now the new rule, Sharon.
Want to cover those? Rules are easier.
Yeah, it's true. The delightful bipartisan Budget Act of 2015.
In the dead of night,
Yep.
they came into being.
Yep.
Okay, if you're born on or after January 2nd, 1954, you will be deemed to have filed for spousal benefits when your spouse or ex-spouse files, regardless of your age. If your spouse or ex-spouse filed before you, when you file for retirement benefits, you will be deemed to be filing for both your own benefit and your spousal benefit. If you're filing before your full retirement age, both will be reduced. And once again, it's a permanent reduction.
Yeah.
And just for an example, say you take your own benefits at 62 and your spouse hasn't filed yet, you're only going to receive your own benefit, reduced of course. Now, if your spouse decides to defer until you reach your full retirement age, you're going to get a full spousal boost. If your spouse decides to file at a time when you're only 64, you're going to be deemed as filing for your spousal benefit at 64, and you will take a reduction on your spousal benefit also. This is why it's so important for spouses to sit down and look at their options, because the decision one makes could very possibly affect the other spouse also.
And that decision also can affect them going into survivorship, widow benefits as well. And we'll get to that in the next couple of slides, why that can be such an important decision.
So speaking of widow benefits.
Yes, that's my area. Okay, the widow benefits. Just as me and my little things looking up, as of December 31st, 2020, SSA paid 5.8 million survivor benefits to survivors. And that equals about 9.1% of the total of Social Security benefits. So it's a small pot, but it's a very important part. So that's widow benefits. Basically, it's, like you said, it's based, if the deceased was receiving benefits because of early filing, survivor benefits base is on that reduced amount, and that's important to remember. They'll come back to haunt you, or haunt your survivor. The maximum survivor amount is based, limited on what the deceased would be receiving if still alive. Now, your survivor benefits before your full retirement age will be reduced. Like any benefit, if you take it early, it's going to be reduced. But the good thing about survivor benefit is not subject to deemed filing, and that's important, as you can see down the road. And the survivor benefit does not go beyond, it doesn't build, you don't get your DR, doesn't grow beyond your full benefit age. Now we'll discuss, you're going to have two different
You may
full-time retirement age for a widow and widower, and we'll discuss that. There's also one thing I want to note it on this. It's a thing about the month of death, or they call it the clawback rule. That is basically a beneficiary must be alive on the entire month to be eligible for benefits for that month. Let's use December 31st. That person dies December 31st at 11:59 p.m. That whole month, because he was not alive that full month, that benefit will not be paid for that month. If the person dies November 1st at 1 minute past midnight, then they would receive benefits for the full December month. Go ahead.
How that works is if you should happen to receive that benefit in your bank,
Yeah.
leave it there. If they didn't live the entire month before, because Social Security pays that month behind.
Yeah.
So they die anytime during the month, even at 11:59 p.m. on the last day of the month.
Yeah.
The payment you're going to receive in the following month is for the month of death. Social Security will take that payment back. So even if it winds up in your bank account, they're going to yank it out. Do not spend it. Like she said,
Why they call it the clawback rule.
and that payment shows up in the bank, you can keep it because they were alive the entire month the payment was for. Now,
Yes.
what happens a lot is sometimes, even though you're eligible for that final payment because they were alive that entire month, it still might be sent back to Social Security. If that happens, contact Social Security and claim it. You are entitled to that payment.
Correct. So next slide. Here you will see what we talked about. Widow and widowers have two different retirement ages. And it's usually the widow or widower's survivor, or the survivor full retirement age benefit is usually reduced by 4 months. So let's say 1958. I wonder why. Usually your normal retirement age, full retirement age is 66 and 8 months. But if you're a widow, it's 66 and 4 months. However, and that's a big however, the earnings test is still based on your full retirement age, not your widow full retirement age. So for that 4 months, you're going to be still subject to the earnings test.
Which is very high at that time.
Yeah, it's basically
If you're making a lot of money, you should be fine. And it
unless
seems
you cost,
weird
you
that
know,
it goes
I
back
obviously made $1 million, but that's another story.
I mean, seems kind of weird that it goes back 4 months like that, but the retirement age is growing 2 months a year. Which
Yeah.
is 2 years, 4 months.
Yeah, so they basically gave you two years off. So, next slide. Now, widow benefits for ex-spouse is it's complicated. The widow can claim survivor benefits early as age 60, 50 if disabled. Now, the benefits will be reduced 28.5%, and that will never change. Okay, so that's important. Next slide. As you can see, this is a delightful chart, and it will give you the date of your birth, your full retirement age as a survivor, and then I'll see how the reductions work out. So, and how the percentage is reduced by how many months. I'm not gonna labor about it. I hate charts, so that's another story. Okay, next one. Okay, so now we got, go ahead.
Am I on the wrong page? No.
Okay, so widow benefits and ex-spouse survivor benefits. If you're receiving a spousal benefit when your spouse passes away, it will stop. You don't get both checks, unfortunately. I know. And if you already reached your full retirement age, you will automatically be switched to your widow benefit. Now, this is the part where I want you to remember closely. If you are under your full retirement age, you will have it actually apply for your reduced survivor benefit if you wish to. Now, this is important, and we'll get to it in a couple of slides. Remember this, okay? This is a strategy that actually Social Security got caught not telling a lot of widows about, but we'll tell you what it is. So the next one is the qualifying survivor benefits. The current spouse must have been married for the deceased for at least 9 months. There are exceptions. And yeah, we won't go there. But as long as, we've had one that's the honeymoon, and we'll leave it at that. And the divorced spouse must have been married to the deceased more than 10 years and be currently single, or married after their 60th birthday. Now, they get married on their 60th birthday because Social Security Administration considers the day before your birthday to be their birthday, where they recognize that as your birthday, not as the actual birth. I don't even know how do they explain that, Sharon?
They consider you born the day before. You always have to remember that if you're born on the first of the year, consider yourself born in the prior year. If you're born on the first of the month, consider yourself born in the prior month. Now, when we're dealing with remarried after their 60th birthday, this is the one time the date of the month matters, because if your birthday is on the 20th, 21st, whatever, when they say after your 60th birthday, they mean after your 60th birthday. So, for example, your birthday is the 20th of the month. The only time you could actually get married right before your birthday would be on the 19th of the month, because Social Security considers you born the day before. But you could very possibly wind up presenting Social Security with their own rules to get those widow benefits. I know that for a fact because I assisted somebody and they did win.
They did win. So, and the widows, and just to know that widow or widowers at any age, if they're caring for deceased dependent children under the age of 16 or an adult child disabled before age 22. So, next one, let's show some examples of survivor benefits. As you can see, widow of full retirement age or old is 100% of the deceased benefit amount. And then the widow age 60 to full full retirement age is 71.5% to 99% of the deceased basic amount. Disabled widows, 50 through 59 is 71.5%. Widow of any age taking care of a child age 16 or disabled is 75%. Child under age 18, 19, if they're still in elementary school, is 75%. And dependent parents of the deceased age 62 or older, as you can see the breakdown. We'll discuss dependent parents, I think, in next week, correct? When we talk about dependents, we go further into all this stuff.
Yeah, I'd like to mention an interesting thing that was not added in here pertaining to when you have a child in care. Specifically, adult disabled child or a child in care, and you are between the age of 62 and your full retirement age. Your older spouse files for their benefits. That's when you would become eligible for that child in care benefit. But the unique part about that period is the fact that if you have one child or one adult disabled child, you become eligible for that child in care benefit. And if you're not working, you can apply for the child, you can apply for yourself, and you'll get 40% of the other spouse's full retirement age benefit.
Yeah.
Only works that good when you only have one child involved.
Yeah, then we'll talk about the next visit. So now here comes the widow limit. It catches a few people off guard. It's often referred to as the RIB, LIM, but I have yet to hear anyone call it that. It's 82.5% of the deceased PIA, what the deceased would have received the full retirement. It only applies if the deceased started their benefits before the full retirement age. This is important. This is when you talk to your husband or wife and you talk about, well, should I take my benefits am I under my full retirement age? You have to think about your survivor going down the road. And just an FYI, you may actually reach the maximum benefit amount before your full retirement age. As you can see that short chart right there. So you reach that cap, the widow's cap. So it's other things.
Just don't forget, even though your survivor benefit's maxed out at 62 and 7 months, you're still under an earnings limit.
Correct. As you said, you still, even though you cap out, you still subject to your earnings limit if you continue to work. And there's some other things that this is where I told you to remember about applying for, if you're under your full retirement age and applying for your widow benefits. A widow can choose which benefit to take first, either the smaller while they're letting the larger grow, or the larger first. Of course, you'll need to do the math. I mean, and this is very important. You must restrict your application, be it to your own benefits or to your survivor benefits only. So this is the important part, because the example is, let's say you reach your retirement age, your benefit will never be bigger than your survivor benefit. You may decide to take your survivor benefit, but if you take it early, you can take a reduction. So if you're 62, you may want to take your benefit early, accept the reduction, and then come to your widow's full retirement age, switch over to your survivor benefit. And this way you're taking it at your full retirement age, and this will be 100%. So that's important, because survivor benefits do not accrue delayed retirement credits. They will grow through COLA adjustments between the time your spouse died and the time you begin collecting your benefits would apply. Okay. And then the last, go ahead.
And just a quick note that, and this is the one time that a spouse taking their own benefits early, it doesn't affect the amount of their survivor benefit whatsoever. Only their age will affect the amount of their survivor benefit.
Okay, so, and then the last bit is the lump sum death benefit, which is $200, 200, no, might as well be $200. It's $255. They've never increased it since conception, correct? I don't think I've ever seen it increased. It's always been $255 since
For a long time.
a very long time.
It grew for so many years and then it stopped, and it's just like they just never removed it from the books because it used to be a funeral benefit. But
Yeah,
now it's just there.
it's there. So now divorced spouses, aren't we? Well, there's a thing with divorced spouses. Divorcees can receive benefits on the ex-spouse work record, but you can't get both. Your ex-spouse can be remarried, but there are rules for divorcees. Marriage must have lasted 10 years or longer. You must not currently be married, and you must be at least age 62, age 60 if your ex-spouse has passed, age 50 if the ex-spouse is deceased and you are disabled. Yeah. This is the interesting part. I remember first hearing this term, and I'm like, independent divorced spouses. What does that mean? And because it's like, okay, I'm independent, I'm divorced. But what they mean, SSA means, is to have been divorced for at least 2 years. Your ex-spouse does not have to be collecting his benefits or her benefits for you to get spousal benefits on their record. And you must be eligible to receive them, of course, at least 62 or on SSDI. Now, the interesting thing is, if you do not remember your ex-spouse's social security number, there is a way around it, Sharon. You have to know what the
File
parent.
Social Security with their name,
Mhm.
date of birth, name of their parents, and if at all possible, where your ex-spouse was born.
Yeah.
Because it's not uncommon for an ex-spouse not to have access to that Social Security number anymore.
Correct.
Yeah.
So don't think it all is lost because you don't have it.
Yeah,
That's what we're trying to say.
it doesn't even affect you when you apply, even if you apply online, because it gives you the option to say, I don't know it.
So now Social Security remarrying. You want to take that, Sharon, or you want to split it?
Okay, Social Security and remarrying, rules for ex-spouses. Normally, when an ex-spouse gets remarried and is receiving a spousal benefit, that spousal benefit is going to end the month before they get married. Normally. There are some exceptions. You would want to find out if any of those pertain to you. Sometimes when you remarry someone receiving Social Security benefits, the 1 year of marriage rule does not apply. Your ex-spouse benefit will end the month before you remarry, and once you're married 1 full month, you'll be able to collect a spousal benefit on your new spouse's record if you're eligible for one. And if you remarry someone that is not yet receiving Social Security benefits, then you're not eligible until your new spouse files. Unless you get benefits on your own record, of course.
Correct, that's true. Yeah, we have to say that, unless you have benefits on your own. So,
And one final thing on spousal benefits that a lot of spouses aren't aware of. Okay, so you file for your benefits, you're getting your spousal benefit, you decide to continue working or you go back to work. Well, you start increasing your own PIA.
mhm.
You can actually increase your own benefit, which is going to reduce your spousal benefit, and you'll get 2 letters from Social Security, one saying you increased your own retirement benefit, one saying that your spousal benefit is being reduced. But when you add those 2 totals together, your total benefit didn't increase at all.
Yeah.
So you can actually work yourself out of your spousal benefit.
That's important to know too. So, Should we, also mention that you can multiple, I know we didn't talk about it, about multiple ex-spouses?
Oh, yes, and we get a lot of questions on, my ex-spouse remarried, what happens now?
Yeah.
The fact that your ex-spouse remarried doesn't affect your spousal benefit if you're eligible one. It does not affect your survivor benefit from them if it's the highest benefit available to you.
Correct.
You could have remarried 3 times and been married to each and every one of them for 10 years. So that would be total of 4 wives that were each married to him for 10 years. And he's a max earner. All 4 ex-spouses, including the current spouse, will receive 100% of his benefit at time of death.
Correct. And it will not affect the other spouses
Not whatsoever.
whatsoever.
No.
That's a point to get across. I think a lot of people get confused
Some
about when you take.
have not even filed because they didn't think they were eligible because their spouse remarried.
Yeah, correct. So I wanted to bring that point up. So next slide.
Good point.
Yeah. Oh, common law and civil unions. This is a tricky spot.
Yes, that's why we're really not going to provide a lot of information on it because it's going to depend on your state.
Yeah.
Very few states allow it anymore.
Correct.
I mean, they can go by case law, public policy, even though the state doesn't officially allow common law marriage. There could be a law that could have you considered and be eligible for benefits. If
There are some states that absolutely outlawed it, do not recognize it at all.
they have to. If you established a common law marriage in a state that recognizes common law marriage and you move to a state that absolutely does not recognize it, they have to accept the common law marriage from the state that did accept it.
Yes, but let's say you started in a state that did not accept common law marriage.
Well,
You moved to a state that does accept common law marriage.
Just like here in the state of Florida,
Mhm.
you could live together for 20 years. There is no common law marriage. There's nothing to get it accepted. You will not collect benefits on your,
So
what do you call it? Well, it's not even a common law marriage.
you're just cohabitating.
On your significant other.
Yeah. So what we usually do is if people ask, we can look it up and say which state does or doesn't accept common law marriage. And then we usually direct them to legal service organization, clerks of the court, and attorneys if required, if it goes into a battle of whether or not they go through, whether or not it's legitimate. I don't know how to actually put it.
We've had a couple of successful cases where the people called back and thanked us.
Yeah.
So I mean, if it's a possible option, it is something to follow through on.
Yeah, correct. Yeah.
And we will give you, like Eileen said, your state laws, your prior state laws, that we will gather for you so you know where to start.
Yeah. So.
Okay, that brings us to the end. Now you can see why I said in the beginning this is going to be a lot of detail
Yes.
on this, and you can also see why I turned it over to the experts. But
Not me, sorry.
but that does conclude our part 2 of the Women in Social Security webinar series. And next Wednesday we will have part 3 where we talk more about dependent benefits and children's benefits and dependent parents benefits. There's a lot of interesting aspects of Social Security that we'll cover there that people are just not aware of.
They're not aware of that one at all.
No, and we'll talk about the whole area of disability. There's a lot of detail on disability, the disability part of Social Security. So we'll spend a fair amount of time on that, and then we'll talk about something called the family maximum, which is the governing item on how much a total total beneficiaries' family can share in his earned benefit. So part 3 will be interesting as well.
A
And
lot of information on part 3.
yeah, part 4, just a quick recap on the final session, we'll be talking about this thing called weapon GPO, Sharon's favorite areas, the impact of weapon GPO on Social Security benefits for people that have worked particularly in governmental jobs.
Teaching
I'm sorry, Sharon?
and teaching.
And
Oh,
yeah.
Teaching is almost becoming more common than government positions anymore.
Yeah. A lot of governments have gone into doing
Have gone into the Social Security system.
We will talk then also about the thing that irritates a lot of people, the taxation of Social Security benefits. That's irritating because it's a surprise to many people.
Yes.
You know, when they enter retirement and start drawing benefits and file their tax returns and find out they have to pay federal income tax on their Social Security benefits. It's a sort of a troubling thing for a lot of people, especially if they weren't aware of it. We'll talk about something called the special lump sum death benefit. We will then talk a little bit about receiving benefits abroad for people that are receiving Social Security benefits but living offshore. There's some issues to be aware of there. And we'll close with some discussion on Medicare, and particularly the hold harmless provision and the impact of the IRMA provision, which is income related monthly. Sharon, help me.
I love he went to you and not me.
Income related monthly. Oh, I forgot.
Adjustment.
That's it.
Allowance adjustment. Yeah.
Yeah.
Income related monthly
Allowance adjustment.
allowance. No, that's not it. Is it?
Amount. Adjustment amount.
Well, whatever it is, we'll talk about it so that you understand it.
We
It
do
does,
know about it. It's just we don't ask. We just go by IRMA.
it does have an impact on your Medicare premium, though, and so that's why.
Monthly adjustment amount.
Yeah.
That's it.
Okay, so with that, we will end today's session and look forward to seeing, in quotes, seeing all of you next Wednesday at 10 o'clock. Thank you
And
very
on a final note, I know we gave you a lot of information today. If there's anything you didn't understand or you have questions on, remember you can call us at 888-750-2622 or email Social Security Advisor at amacfoundation.org. We are here and available to answer all your questions.